Welcome to Environmental Law Explored, a podcast series, the podcast of the American Bar Association section of Environment, Energy, and Resources. CEER is a member organization whose mission is to foster the success of a diverse community of environmental, energy, and resources lawyers, advisors, law students, and decision makers, and provide a premier forum for the exchange of ideas and information.
Good afternoon. My name is David Rieser. I'm with Web Counsel with the law firm of K&amp. I'm based in their Chicago office. And with me is Amy Edwards, partner in Holland and Knight, and based in their DC office. And we're going to be talking about PFAS and environmental due diligence. Among Amy's many attributes is that she has the intestinal fortitude to sit in on numerous ASTM meetings, which makes her one of the country's experts in how ASTM develops its phase one methodology, and a great person to talk about the application of that methodology to PFAS. Amy, do you have any beginning remarks before we get going?
Thank you, David. I am a partner in the Washington, D.C. office, Holland and Knight. And as David mentioned, I'm actually one of the founding members of the ASTM E-50 committee. Was honored with that distinction, if you will, in 2020, and have received a couple other awards from ASTM over the years for the work that I have done with them. So I'm not sure I have much more fortitude to do many more years worth of ASTM work, but I have learned a little of the ins and outs of phase one standards in particular over the 30 plus years that I have served on the E-50 committee.
Excellent. And just to backtrack on something, I've been practicing environmental law for more than 40 years, and I share Amy's lack of intestinal fortitude for another 40 years, but we'll see what happens. So we're going to be talking about PFAS now. And so why are we talking about this? What are PFAS, and why do they matter for the purpose of environmental due diligence? So PFAS are, we get the name right, per and polyfluoroalkyl substances, and these are man-made chemicals that have been around since the 1940s. They do not break down easily, which makes them great in each of their applications, but it also means that they are considered forever chemicals for the purpose of the environment. They are resistant to water, oil, grease, and heat, so they are used in a number of different applications, such as nonstick pots or water-resistant clothing and things of that nature. And they have been found all over the world, both in Antarctica and Himalayas, obviously a long way away from any recognizable source. And they are considered by some to be ubiquitous, but they're not really, because you can't find them absolutely everywhere. But one of the problems, of course, is that for a variety of reasons that we'll talk about, when we look for PFAS, when we sample for PFAS, we'll be sampling at the parts per trillion level, which is an incredibly small number. So why are we talking about this in the context of environmental due diligence? So remember that among the liability protections under CERCLA, people can assert the state of their knowledge of environmental contamination on a given property prior to the time that they purchased the property as a defense, essentially, to CERCLA liability. So these are matters of asserting an innocent purchaser defense, a bona fide purchaser defense, or an adjacent property owner defense. But each of these requires the performance of all appropriate inquiry. And all appropriate inquiry is done subject to EPA regulations, which allow for the use of the ASTM phase one methodology as a means of performing all appropriate inquiry. And the key to doing that work is to identify recognized environmental conditions which require the identification of releases or potential releases of hazardous substances. So when ASTM met to produce its most recent methodology, they stated very clearly that consultants, environmental professionals who were performing due diligence did not have to look for PFAS until EPA identified them as hazardous substances. EPA has now done so, in addition to setting groundwater standards and health and risk-based standards for PFAS. They have specifically identified several PFAS compounds as hazardous substances, which means now that it is a valid question to ask whether or not PFAS need to be evaluated as part of a phase one, and even more importantly, how we do that. So, Amy, let's talk about how a lawyer dealing with this issue and representing a client who is seeking a phase one to be performed, how they deal with the PFAS issue and how they structure the phase one around that problem.
The first thing that lawyers should recognize is that due diligence is an exercise in evaluating risk. So there are several components to that. First of all, what is the nature of the transaction? Is it a straight acquisition of real property where the purchaser would potentially become liable upon becoming the owner of the property? Is it a corporate transaction where there may be other mechanisms that can be used to allocate risks between the parties? Is this a site that has a history of industrial use where some kind of PFAS compounds are likely to be present? Because you don't want to go crazy if there's not a likely source of PFAS contamination on the property. But we also have to recognize that there are thousands of chemicals in the PFAS family. Only 2 of them are currently regulated as hazardous substances under CERCLA. That could change, so you shouldn't be blind and willfully ignorant about other types of PFAS compounds that could be present on your site depending upon how it was used. But on the other hand, remember that there's only 2 that have officially been declared to be hazardous substances at the present time. But the first thing one should do is talk with the client and with the client's advisors, namely their environmental consultant, about what's the history of this site. Is there likely to be a source of PFAS on or near the site? Database companies are doing a much better job of flagging sites that potentially had industries with use of PFAS compounds in their databases. So the information can be quickly gleaned in many circumstances with a good historical research search, with use of the databases, with good interviews of the key managers at the facility to have a better appreciation for whether PFAS is really a significant risk or not at that particular location.
So in doing that, well, let's talk a little bit about what are some of the industries where you would be particularly concerned about PFAS, and then I've got a follow-up.
Well, you've already identified some of them. Obviously, any industry that created waterproofing fabrics, but waterproof or water-resistant carpeting and other kinds of textiles, paper manufacturers, semiconducting materials, chrome plating facilities, food packaging facilities. Also, many cosmetics contain PFAS. So they've been used in a wide range of industries, but be sensitive to at least the shorter list of industries that are more likely to have used PFAS as part of their manufacturing operations, and be particularly sensitive to those facilities.
So another couple of facilities to add to that list would be landfills that have collected refuse from a wide variety of sources, and airports, at which people use PFAS as a fire retardant, both for testing, for practicing to protect against catastrophes, and in actual dealing with airplane fires.
There's aircraft facilities and other chemical manufacturing, storage, transport facilities, military facilities as a general rule, but certainly any kind of industry such as a refinery that might have needed to use what they refer to as AFFF foam, firefighting foam, to potentially quell a fire at the facility, are facilities that one should be taking a more close look at.
So I'm not sure we've narrowed down the types of industries out there. We'd also be worried if any of these things were nearby, like if it's a facility in an industrial area next to an airport, that might be one where you'd be concerned about.
That's a fair point, David, because the one thing that we have learned in recent years about PFAS contamination is that it tends to migrate great distances, particularly when it gets into groundwater. So if there's a military facility or an airport, a chemical storage facility, say within half a mile, you may want to be taking a much closer look at that circumstance to see whether there is a possibility that contamination at that source could potentially reach your target subject property.
So when we're dealing with a consultant who's performing a phase one for a client, what are our expectations in terms of the information that a consultant would provide in a phase one? Would they say, oh, there's potential for PFAS here, or there's not a potential for PFAS here, or not mention it, or identify it as a data gap? What do we think people are going to say in a phase one for these types of properties?
It's really important to have that conversation with the consultant before they begin their work to be sure that you're on the same page as to what your expectations are. Again, recognize due diligence is an exercise in risk management. So if you decide that there is a release that might have impacted the subject property, what is your likely next step? So you want a good look at the historical record as to the kinds of facilities on or near the site that might have used PFAS as part of their operations. You also want to assess whether there's a good likelihood, low likelihood. It shouldn't be just a risk of a release. The one thing that ASTM did with the most recent update to the phase one standard was to be sure that those hypothetical, it could have impacted the property kind of conclusions are not drawn. You're looking for a release or, a real threat of a release that would have impacted the subject property. So that is much clearer in the current standard than it probably was in prior standards.
So we're looking for an actual rec finding or no rec finding, recognized environmental condition or CREC or the rest of the recs, rather than business risk or some of the other broad categories that some consultants will put potential risks in.
Yes, and that's why it's important to have a conversation with the consultant before the work begins. So you have a conversation about, are there any suspect sources on or near the site? And what are you going to do with that information once you've nailed it down in more detail?
So you mentioned earlier that, correctly, of course, that EPA only listed a couple of the many thousands of PFAS as hazardous substances. In what way does that affect how the consultant goes about their work of evaluating a property for the potential for PFAS contamination?
Well, if you recall the footnote that ASTM included in the phase one standard in its most recent update, no PFAS substances had at that time yet been designated as hazardous substances. So it made clear at that time that there was no obligation to look for any PFAS compounds as part of a routine phase one. That has now changed because now two substances clearly are hazardous substances. And I think the parties would be at risk if they did not make some effort to identify whether PFOA or PFAS was present on the property. But one also has to recognize that there's a lot of regulation of various PFAS compounds at the state level. So you might be in a jurisdiction such as New York, New Hampshire, some of the Michigan, some of the Midwestern states, where there are other substances that are considered to be hazardous substances under state law. So it's important to be sure that you're taking that full legal environment into consideration when you're doing your due diligence work. And also recognize that under the Safe Drinking Water Act, we now have final drinking water standards that include, I believe, 8 substances, substances that now have regulatory limits, MCLs, and also that EPA is considering regulating, I believe, 9 substances under the Resource Conservation and Recovery Act. So this is a moving target. It's important to keep your eye on what the regulatory environment is doing and look out for those risks and address those risks in some manner as part of your due diligence.
When we talk about risks and the purpose of doing due diligence for phase ones, I always tell people is twofold. On the one hand, you want to qualify for the potential defense, but on the other hand, you want to know what's going on so that people can evaluate the value of the property, whether there are environmental risks associated with the purchase, whether there's work that they would have to do to address those risks, whether they can redevelop the property, all of those things that go into the decision to purchase. One of the things about the PFAS issue, one of the things about the PFAS issue is that because we're dealing with such small amounts, it's not clear how you would actually address a PFAS problem at a given property, whether that would be mediation, whether it would be leaving it in place, things of that nature. Those aren't necessarily phase one questions, but they're certainly quiet discussions in going into a phase one about what you do with the results, what you do with the finding that there's potentially PFAS there. Do you have any thoughts about how you have those discussions?
You raise a really valid point because some people do treat a phase one as a check the box exercise. But again, this is an exercise in risk management. So what you're going to do with the property involved in the transaction going forward is critical to how you approach those conversations with your client. So if you're redeveloping a property that might have PFAS on it, there are clear cost implications of figuring out how you're going to address that issue. Are you going to go through a state voluntary cleanup program? Can you get the seller to pay for some of the costs of cleanup? What standards are likely to apply? All that needs to be understood before you go too far down that path. On the other hand, in many corporate transactions, there may be other mechanisms to deal with potential PFAS contamination on a site. I was recently dealing with a transaction in which we discovered kind of at the 11th hour in the due diligence process that the existing tenant on the site have disposed some hand sanitizer that caught fire, and the firefighting department came by and put it out with AFFF foam. So how is that going to impact our transaction? Well, we were able, because we were going to be a tenant as well on that site going forward, to get broad indemnifications from the seller because we didn't know whether PFAS was in fact on the property. We assumed it might be, but we weren't going to be using PFAS. We shouldn't have any connection to PFAS contamination, and we just wanted that additional contractual protection in the event that any agency in the future were to pursue the landowner, which was not going to be us, for remediation issues.
Yeah, and that raises yet another point, which is we've been talking about this from the perspective of the buyer. Buyer is doing the due diligence, but the other perspective, of course, is the seller. In representing sellers, I'm sure you've had the same experience where they're concerned about people coming onto their property and doing environmental due diligence, a concern that the diligence will identify problems that they weren't aware that they had, or certainly weren't aware that somebody else would discover them, and that discovery, that information would have an impact on their ability to transfer the property. I've recommended to some clients that they go ahead and do their own phase one, so they're not surprised they don't get the information in the context of the transaction when you tend to have less time and less leverage to deal with the problem than doing it on your own. But people don't always want to take that step. I've also, as you have, I'm sure, had the experience of having sellers be very cautious about how they allow environmental due diligence to be performed, even recognizing that in order to sell the property, they have to allow it. From a seller's standpoint, does that change any of the discussion that we have? Do we have a different discussion with the sellers?
I don't think it changes the conversation so much as perhaps raises this as a new increased scrutiny issue, because many sellers, as you know, a phase one does not include intrusive sampling. So whether there will be intrusive sampling before the purchase goes forward is always negotiated between seller and buyer. Some sellers are adamant that they will not allow any intrusive investigations whatsoever on the property. And if you were the buyer in that circumstance, you'd have to evaluate what the factors were or the risk about whether that would be prudent to proceed if you were not allowed an opportunity to sample before you were able to take title to the property. We have sometimes had situations where we tried to draft as a seller very narrow circumstances under which a buyer would be allowed to do any phase two testing. It's really easy for a buyer to find a reason to qualify for one of those limited exceptions. So as a seller, you really need to think about this carefully in terms of how risk adverse are you? Will the deal go forward with this potential purchaser or someone else if you don't allow them to do sampling?
Right. And that's why I always recommend to people who are considering selling to have a thorough discussion about how they want to handle the environmental assessment, because one can't assume that the phase ones that are produced are going to go away somewhere or not be available. And if you get a copy of the phase one as a seller for a buyer who doesn't go forward with the property, you may have to disclose that phase one to the next buyer just as part of the contractual requirements to disclose any, they're frequently in contracts to disclose any environmental reports that you have.
That's a very good point. And it also raises the issue of whether, as a seller, you should have any say over who the buyer uses as their consultant, because we know that there's a huge variability in terms of the quality of the phase one reports that are produced out there. And related question would be, can you convince the buyer not to share their phase one with you if you think it was either poorly done, inaccurately done, whatever, so that you as a seller do not have that document in your files?
Okay. Well, that brings us to another issue, let's call it the dark side of due diligence, which is that both the parties to the transaction or the consultant itself sees the opportunity to use these for financial leverage. The buyer or seller taking environmental information and using that discussion as leverage for price changes, even though the environmental issue may not have any price associated with it. And the consultant using the opportunity to identify a broader range of problems than there might actually be in order to do more work on the property. And this, because of the uncertainties associated with PFAS, I would think that this would be a ripe opportunity for people of this persuasion to game the system, if you will. So obviously this would start with a good discussion with the consultant and thorough vetting and a discussion internally with buyer and seller, depending on who you're representing, on what the contract terms are for the due diligence. But do you have other thoughts about specifically how we deal with this?
It's a very fair point. And we all know that there are some consultants out there who find a recognized environmental condition left and right, whether they really should be concluding that a particular circumstance is a wreck or not, which again is why it's so important for a seller to potentially have some say over who the buyer uses as their environmental consultant, and also has the opportunity to push back if that consultant pushes hard or additional investigation, particularly intrusive investigations, which you as a seller don't feel are appropriate. So it's good to have some control over this entire process as much as you can.
So we've been talking about this in terms of real estate transactions, but we also do due diligence for corporate transactions or any transitions in company ownership. Is the approach going to be any different when we deal with corporate transaction as opposed to real estate transaction?
It will be slightly different because as part of a corporate transaction, you're also looking at the compliance status, or should be looking at the compliance status of the existing facility on the site. So it becomes much more important to be sure that you evaluate whether the facility has all the necessary permits. Do the permits have anything to do with potential PFAS contamination? Are you reviewing safety data sheets to, again, determine whether there might be any products that are being used on the site that could contain PFAS contaminants? Also, just product inventories. What kind of material is going in and out of this site? So there's a lot more that one should be doing as part of a corporate transaction to have a much better grasp of the historical uses on the site and the compliance status of those activities on site.
So it's a broader look when you're doing a corporate transaction, just because you have to look at so many other things in addition to the condition of the real estate.
Yes, it should be a broader inquiry. We always recommend when we're asked that the company do a limited environmental compliance audit as part of its what would otherwise just be a phase 1 ESA.
So I haven't seen this discussed anywhere, and I don't know the answer, but is it your experience that safety data sheets identify PFAS if it's a minor ingredient or part of the process or something else?
You may need to bring your consultant in to really evaluate those sheets, but I know because I've been looking at this recently, you can find it's substances that have carbon and fluorine compounds. So that's a jumping off point for those of us who are not technical experts, but it's enough to say, oh, I think I should have my consultant looking at this more closely to see whether PFAS compounds are being used by this facility.
Excellent. Turning back to ASTM after all of this, is ASTM considering making any modifications to its methodology to deal with the PFAS evaluation? I'll use the example of the methodology they developed for soil vapor intrusion at a time when that was becoming much more component of risk evaluation for property. And they developed, so they wanted the consultants to have a roadmap for how they evaluated soil vapor in a situation where they didn't have any data, they didn't have any intrusive sampling. And so they identified what they should be looking for to make a decision on whether or not there was this potential soil vapor issue. Are they considering doing something similar with PFAS?
To date, there's been no discussion about creating either an enhanced phase 1 or a separate document that actually looks at this risk from a due diligence perspective. There have been some efforts to look at remediation techniques, and I expect that ASTM will be probably developing some other standards in terms of sampling and that sort of thing. But to date, there's been no discussion about having one that's more focused on the due diligence aspects of transactions. That could change. Obviously, vapor intrusion was done because there was a concern that too many consultants were finding a vapor encroachment risk when parties did not feel that there really should be a concern about vapor within a building. So with time, we may see a similar concern surface here.
We've been talking in terms of the main phase 1 methodology that people use for looking at individual properties, but there's another and very similar methodology that people use for looking at large properties, at forested properties or agricultural properties, and that's known by its number E-2247-16. And I've come across a lot more of those types of audits looking at renewable energy facilities that are going up on agricultural land or rural land, where they're looking at acres and acres of property rather than one facility. Are the PFAS issues the same for this under this methodology as they would be under the E-1527 methodology?
Yeah, they should be pretty much the same. The 2247 standard is typically updated a few months after the 1527 standard is updated. So they try to march in parallel as much as possible. So the issues are really the same under the two standards.
And then one other source that I don't think we've talked about with regard to particularly agricultural properties are the use of biosolids from wastewater treatment plants, which are one of the key concerns in looking at the CERCLA liability for all, as EPA was looking at the CERCLA liability for all of this, was that the biosolids from wastewater treatment plants were spread over vast areas of agricultural land, and whether that would, since PFAS are frequently present in biosolids, whether that would present a broad risk of CERCLA liability for the agricultural community. So that would be something that one would look at if you were doing this type of an assessment under 2247 of agricultural property.
The one thing that it's important to take a look at is EPA issued an enforcement discretion policy at the same time that it finalized its listing of PFOA and PFOS as hazardous substances. And in that document, EPA tried to clarify that its primary enforcement focus was going to be against manufacturers and big users of PFAS-containing substances, with the idea that facilities that generated biosolids should not be a major target of enforcement. We all know that this is just a discretionary policy. It only binds EPA. So private parties obviously could approach the situation differently, but that is EPA's position in terms of not taking high priority actions against properties that just might be contaminated because there was some PFAS in biosolids that were spread on the property.
Yeah, absolutely correct. Of course, the issue from a liability standpoint is the private property concern as well as the value concern. So if you have people who are in the business of buying up agricultural property and buying and selling agricultural property, they'll want to know if this is present before they buy it so they know they can sell it. And there would be nothing that would prevent a buyer of agricultural property contaminated with PFAS from bringing an action against the owner under CERCLA.
It's a fair point. And we're just going to have to see with time how this plays out, because yes, if you're buying a property like that and you know biosolids have been spread on the property, there's a decent chance that there could be PFAS contamination on the property. So are you going to rely just on EPA's discretionary enforcement policy? Can you find some other type of relief from the seller, relief through insurance, some other method? We're told that older CGL policies might present some coverage if you're lucky enough to have old comprehensive general liability policies, but time's going to tell how this plays out.
Yeah, we'll have to do another of these on the environmental insurance aspects of this issue, because that's going to be one of the next wars going forward. Anything else that we missed in our discussion? I mean, there's a lot of other issues involved in this, and wasn't our idea that we would discuss phase 2 issues in this context or other problems. But I think that was the focus for us, was just looking at how we do phase 1s in this new world.
I think there's pretty genuine consensus at this point that consultants should be looking for at least the two officially designated hazardous substances, PFOA and PFOS. And obviously, if your transaction is occurring in a jurisdiction that heavily regulates PFAS, you should be taking those state laws into consideration as well. And again, think about the risks before you get into the due diligence process. Talk with your client about how you might handle that risk if you find it. Get a good handle on whether there are any of these industries that typically have used PFAS that have operated on or near the property, and that should put you on a good path.
Yeah. And just to underline a point strongly, Amy mentioned that there are people who use the phase one process to check a box, and this is not the time to do that. This is a process that ought to be thoughtful, that ought to drive one's own thoughts about how the transaction will proceed and what risks are involved. And so that requires first a discussion with the client about what those risks are, why you're doing a phase one, what people should expect to get out of it, and a discussion with the consultant about what their role is and how they are looking at things. Fortunately, sometimes you use the same consultant for a number of different transactions, and so you already have a good working relationship. In those circumstances where you don't have that, it's important to be on the same page in terms of how they will be approaching what's essentially a new issue for which they don't have a lot of guidance.
And an issue area that could be very expensive. So that's why it's really important to have those conversations and understand what your strategy should be before you start embarking down that path.
That's our discussion for this issue. I think there's other issues out there in the due diligence world that maybe we'll take on at a later date. But until that happens, thank you for joining us for this podcast, and have a good day.
Thank you very much.
We hope you enjoyed today's episode. To learn more about our section, please visit our website at americanbar.org/envira. Please check where you found us for future episodes. Thank you for listening.